judgment in the appeal, Queen against Waya.
Lord Walker will give the first judgment.
In 1986, Parliament enacted the Drug Trafficking Offences Act in order to deprive convicted drug dealers of their ill-gotten gains. Since then, the legislation providing for the confiscation of the proceeds of crime has widened in its scope and increased in its severity. It is no longer limited to the proceeds of serious organized crime, though there are particularly stringent provisions that apply to persons with a criminal lifestyle. The court no longer has a discretion as to the amount of the confiscation order, which is to be calculated in accordance with provisions now found in Part 2 of the Proceeds of Crime Act 2002. Those provisions have given rise to many difficulties of interpretation, and they sometimes produce a result that appears disproportionate. A confiscation order is not intended to be an additional punishment for a convicted criminal. Its purpose is to prevent that person benefiting from his crime. In 2007, Mr. Waya was convicted on one count of obtaining a money transfer by deception, contrary to Section 15A of the Theft Act 1968. He dishonestly gave false information about his financial position in order to obtain a mortgage loan of £465,000 to buy a flat in St John's Wood, London. He made a down payment of £310,000 out of his own money. By the time of his conviction, the loan had been paid off and the mortgage lender lost nothing. He was sentenced to 80 hours community punishment. Then there was an application under the Proceeds of Crime Act, and a confiscation order was made in the sum of £1,540,000. This represented the then market value of the flat, less the down payment of £310,000. On appeal, the Court of Appeal interpreted the legislation differently and reduced the amount to £1,110,000. There was a further appeal to the Supreme Court, first heard last year. The Court then directed that because of the importance and difficulty of the case, it should be re-argued, and it has been re-argued before 9 justices and with the assistance of counsel instructed as advocates to the Court, and on behalf of the Secretary of State for the Home Department. The Court's judgment is in 2 parts. The first part is in sections 1 to 3 of the majority judgment. This part, which is unanimous, deals with the general issue of most public importance, that is, the issue of proportionality. The Court holds that Part 2 of the Proceeds of Crime Act 2002 must be interpreted in accordance with Section 3 of the Human Rights Act, so that a confiscation order may not be disproportionate. Disproportionate orders would infringe Article 1 of the First Protocol to the European Convention on Human Rights, by which everyone is entitled to the peaceful enjoyment of their possessions. This does not introduce any general discretion, which would be a matter for Parliament, but it ensures that compliance with the Human Rights Act is in the hands of the judge and not just the prosecuting authorities. The second part of the judgment, sections 4 to 9, applies the provisions of Part 2 of the Proceeds of Crime Act to the case of Mr. Waya. There are several technical issues which are incapable of brief summary. The majority, composed of 7 justices, allow the appeal to the extent of substituting a confiscation order in the sum of £392,400, which is not disproportionate. There is a dissenting judgment of Lord Phillips and Lord Reid, who disagree with the reasoning of the majority in several respects. They would allow the appeal and make no confiscation order.